I noticed that we also have the third member of the tribunal. Good morning, Ms. Knappert.
Good morning. Hi, sorry about that. I had the wrong link for some reason.
No worries at all. I have a breakout rooms with. Wait, 1 second.
So all the teams are present, right? We have the respondents and the claimants. Are the claimants in the room?
Yes, the claimants are all in the room.
Okay, so please all switch on the cameras and we will give the floor to the tribunal so that the hearing can begin. Thank you.
Good day, everyone, and welcome to this final of the 2021 edition of the cross-examination Moot. My name is Sophie Neppert. It's my great privilege to be chairing this tribunal with my colleagues, Professor Lucas Mistelis and Professor Franco Ferrari. We are very much looking forward to hearing you. And I am told, I have been explained the format. I am told that you are all aware of the time division. Perhaps just before we start, for the sake of good order, I would ask the claimants team to introduce themselves, and then the respondents team likewise afterwards, please. The claimants.
Good morning, Madam Presiding Arbitrator and members of the tribunal. My name is Devansh Kaushik. Today I, along with my colleague Darshan, am here representing TEPC in these proceedings. I will be conducting the direct examination of our witness, Mr. Alex Hertz, and then Darshan will conduct the cross-examination of Mr. Taylor Jewell from AGB.
Thank you. For the respondent, please.
Honorable members of the tribunal, my name is Katerina Kirichenko. I'm part of Yaroslav Mudry National Law University team, and we represent AGB Construction Enterprises in the current proceedings. Me and my colleague, Vsevolod Martsenyuk, will do the cross-examination of the witness, and my colleague, Roman Krochmal, will do the direct examination of Mr. Jewell.
Thank you very much. I don't think there's anything from my colleagues at this stage, nothing. So please proceed.
Before we begin, Madam Presiding Arbitrator, may I request you to administer the oath to the witness as required by clause 6.3 of procedural order number 2.
I'm sorry, I missed that. Say again, please. You were requesting?
My request is if we may administer the oath to the witness as is required by clause 6.2 of the procedural order number 2. With your permission, Madam Arbitrator.
Yes, please.
For your convenience, I can put it on the chat.
That would be great.
Mr. Hertz, over to you.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Hertz. Madam Arbitrator, with your permission, may we proceed?
Yes, please.
Thank you. Mr. Hertz, please state your role in TEPC.
I'm the commercial manager at TEPC. I focus on wind energy projects largely.
What was your role in the Dawn Wind Farm project?
I negotiated the EPC contract with AGB. I was contract manager and I oversaw the project.
Right, you have submitted 2 statements as part of the record, I believe, on pages 130 and 140.
Correct.
Point of order, Madam Presiding Arbitrator, may I please request permission from the host to enable screen sharing?
Yes.
It should work now.
Yes, thank you.
No worries.
To confirm, Mr. Hertz, these are your statements.
Correct. This is my statement.
You confirm this is your signature?
Yes, that's correct. This is my signature.
Thank you. Mr. Hertz, can you tell us about the deadline for the completion of the project?
As per the contract, the deadline was 1st July 2019 to finish the project. AGB readily agreed to this. They did not raise any concerns at the time of negotiation of the contract. And in fact, they assured that AGB was accustomed to working under tight schedules.
All right. Was the project completed on time?
The project was not completed on time, and AGB caused huge delay of 366 days over the contractual limit. Because of these delays, TEPC had to suffer multiple losses.
Can you tell us more about the issue of extension of timeline?
Under the contract, there is a requirement of change order or addenda, and there were no change orders or addenda. AGB informed us that they cannot meet the timeline. We tolerated it, hoping that the delay would not be more than a few weeks. To clarify, we never agreed on an extension of the deadline, nor a waiver of penalties, because that would have, as I said, required a formal amendment to the contract.
Can you tell us more about the delay in this project?
Sure. AGB caused significant delays. They did not adhere to the contract. Right at the start, they did not submit a proper bank guarantee. They also did not plan their schedule properly. For example,
Can you tell us? Sorry.
For example, they did not plan according to the well-known rains in Dawn, and they took almost a year to procure the coating.
Mr. Hertz, can you tell us about TEPC's conduct during this project?
Sure, we acted entirely as per the obligations in the contract. We did not do anything to delay the project.
Finally, Mr. Hertz, can you tell us about the losses that TEPC suffered as a result of the delay?
As a result of the delay, we missed the higher feed-in tariff rate that was to be provided by the Westerly government. We had to pay other vendors to get the blades painted black, and we also suffered losses due to the production starting 1 year late.
Madam Presiding Arbitrator, I have concluded my direct examination. Over to you.
Thank you very much. Well, over to whomever is going to cross-examine this gentleman, I guess. Please proceed.
Mr. Hertz, good day. How are you doing?
I'm doing well, thank you.
Great. Are you ready to start the cross-examination?
Whenever you're ready.
Honorable Tribunal, if you do not object, we have started sharing the screen for your convenience. Now, Mr. Hertz, could you please tell that the initial tender offer of AGB was 500 days? Is this correct?
From what I recall, yes, but if you can put the specific document up, I would be able to help much better.
Great. Could Mr. Krochmal please guide us to the page 138, namely to the paragraph 8. This document is your own witness statement. Do you recognize
Absolutely.
it?
I
Yes. Here in the para 8, we can see that the initial offer of AGB was 500 days. Is this correct?
do. Correct.
Good. And in the course of negotiations, you had proposed 400 days for the project to be completed, did not you?
We did.
Now, I would move on to the page 67 of the record. This is an email. Do you see it well?
Counselor, I'm actually not able to read it properly. Would you mind if I open it on my hard copy of the record?
Sure, whatever is preferable for you. Now, do you recognize an email from you dated, just a second, dated, I can see it quite well, 6 March 2018.
So I think the email is dated 5 March 2018 and not 6 March.
Yes, dated 5th March 2018. Do you recognize this email, Mr. Hertz?
Yes, Counselor, this is my email.
And this is an email where you propose 400 days to for the project to be completed. Is this correct?
That is correct, Councillor.
Now, did Mr. Jewell follow with a follow-up email to this one?
Yes, Councillor.
And the email on the screen is the email where Mr. Jewell has expressed his willingness to meet such a deadline. Is this correct?
I'm sorry, I'm unclear about your question.
Now, the email of 6 March 2018 is an email where Mr. Jewell has provided that he is willing to help you to meet such a deadline. Is this correct?
That is correct.
Now, did Mr. Jewell in this email warn you that he was concerned about the factors that could be outside of AGB's control? And this is stated in the paragraph 3, and the paragraph starts with as I've mentioned before, what concerns us are factors that might be outside of our control. Was it mentioned in that email?
Councillor, this was a very long question and I couldn't understand exactly. Could you rephrase it, please?
Council, are you asking Mr. Hertz to confirm the contents of this email? Is that what you're doing?
Yes,
I'm just
Madam
trying to figure out where you're going.
Yes, Madam Presiding Arbitrator, as this email took quite a long time ago, I was just making sure that the witness is quite aware of this document.
I mean, I think you can ask him that question. Perhaps that's going to allow you to move on. Thank you.
Thank you, Madam Presiding Arbitrator. So now, Mr. Hertz, do you agree that Mr. Jewell communicated that he was afraid that some of the factors could go beyond his control?
I am not sure afraid, but he says that he was concerned. So I think we should be careful with the terminology being used.
Now, Mr. Hertz, I'm sorry, there seem to be problems with sound. So did Mr. Jewell warn you that the successes of previous projects depended on cooperation between the parties? Was it implied from that email, Mr. Hertz?
Counselor, I cannot say what was implied from the email. I can only tell you what is there in the email.
All right. Now, could you please take a look at the paragraph 3 of this email and state and just read the first sentence once again?
Sure.
Sorry, excuse me, witness. I'm at the next paragraph, please.
Counselor, which paragraph? I was reading the third paragraph from what I understand.
Then wherever we have agreed on the ambitious deadlines.
Sure, sure, Counselor. Whenever we have agreed to ambitious deadlines in the past, the owner committed to providing guidance on regulatory matters or releasing us from liability from them altogether.
Thank you. And Mr. Hertz, have you ever objected to any of those statements in any follow-up emails or anything like that?
Counselor, this might be the initial position in our negotiation, but this is not what was agreed in the contract. You have the copy of the contract and you can see what was agreed from the contract.
Mr. Hertz, allow me to ask the same question. It was a very easy question. It was a question in point. So the question was whether you have objected in any way. And we understand what your position is clearly, but it was a very precise question. And I would like also to get a precise answer.
Mr. Arbitrator, my apologies if my answer wasn't precise, but the question of the counselor was that in any form did we object it? And since the position is reflected in the contract, that also means that we did in fact discuss this issue further at a later point in time and agree to a certain position. That is what I'm trying to clarify, if that helps, Mr. Arbitrator.
Yes, thank you.
Thank you. Thank you, Mr. Arbitrator.
Now, if honorable members of the tribunal do not mind, I will move to the next issue, which is the issue of the upfront payment. Now, Mr. Hertz, is my understanding correct? TEPC was interested in finishing the project as soon as possible.
AGB was or TEPC was? TEPC was.
Yes.
Yes.
Thank you. And TEPC has tried to do everything possible to meet the deadline. Is this correct?
Everything as stipulated by the contract, correct.
Now, and I would like to move on to the page 57 of the contract. This is the EPC contract, please. Now, Mr. Hertz, was the upfront payment necessary to start the construction of the Dorm wind farm?
Counselor, I'm unclear on your question because from what I can see on the screen, there's a definition of upfront payment.
Now, I will paraphrase the question for you. Was upfront payment a condition precedent to start the construction of the Dorm wind farm?
Counsel, this is not a legal expert. It's a factual expert. Are you asking him to interpret the contract?
No, Madam Presiding Arbitrator. Mr. Hertz was the one in charge of the negotiations of the contract. And what I'm asking is simply, was upfront payment required for the construction works to start? This is quite a simple question, and it is also reflected in his witness statement.
So you're asking him from his perspective as the commercial negotiator for his company?
Yes, Madam Presiding Arbitrator, your understanding is correct.
Thank you. Mr. Hertz, are you able to answer that?
Madam Presiding Arbitrator, to the extent that it involves interpretation of the contract, I'm afraid I'm not a legal expert. But to the extent that I was the negotiator for this contract, I do believe that it was a condition precedent in the contract.
Thank you.
Now, Mr. Hertz, and to obtain the upfront payment, the guarantee had to be obtained. Is my understanding correct? The first demand guarantee.
I'm a little unclear on your question.
So, did AGB have to provide you with the first demand guarantee for the upfront payment to be paid by you? Is my understanding correct here?
Yes, that's
now,
correct.
Mr. Hertz, and so without the guarantee, the construction works could not start. Is my understanding correct?
Could not start. I think that's correct.
Now, let's move to the page 73, the exhibit C6, please. Now, and let's scroll down a little. Yes, scroll up, please. Now, do you recognize this email that is in front of you? Can you please zoom in, Mr. Krupman?
Sorry?
Mr. Hertz, do you recognize the email
Yes.
in front of you? And was it
I do.
sent?
This is an email from. This is an email from Taylor to address to me, sent on 4 June 2018.
Yes, correct. And could you please clarify, did Mr. Jewell send to you the bank guarantee that was requested?
The bank guarantee that was requested was the one that complied with the provisions of the contract. So I would say that no, Taylor did not send me the bank guarantee that was requested.
The question is simple. Was it the email where Mr. Jewell sent you a guarantee? Was it or was it not? Just a guarantee?
Yes, correct.
Now, and did he also mention, please look at the highlighted pink part. He said, I would need you okay at the latest tomorrow. Was the next day, 5th June 2018? Is this correct?
Yes, that's correct.
And he said that it was required to meet the upfront payment deadline. Did not he?
That's correct.
Now, do you remember, Mr. Hertz, when did you reply to Mr. Jewell? Sorry, when you replied.
From what I remember, I replied on 6th June, but you can correct me if I'm wrong.
Yes, you were correct on this. And did you approve the guarantee in this reply?
I did not approve the guarantee because it did not.
Sorry, Mr. Hertz, the question is simple. Now, and in this email, please scroll down a little. Scroll down, please. You said that the guarantee did not match TEPC's corporate standards, correct?
Could you please highlight the relevant portion you're referring to?
Now, yes, thank you.
Yes.
And you also said that it did not, it was not in line with the market guarantee, with the modal guarantee. Is my understanding correct? The modal guarantee being provided in the exhibit.
The exhibit of the contract, correct.
Now, so those were the two reasons for which you rejected the guarantee. Is my understanding correct?
The reason is that it did not also meet with the market standard, apart from these two reasons.
Mr. Hertz, did you say it anywhere in the email that it did not meet the market standards?
I may have not said that in the email, but since it says in the contract, so I assume that Taylor would know about it.
Now, Mr. Hertz, let's take a look at the sentence that starts with, I had our legal team review. Do you see this sentence, Mr. Hertz?
Yes, I do.
Now, you provide that it does not align with the corporate standard, and then you set out 3 criteria on how it does not comply with the corporate standards, do you not?
3 criteria, yes.
So you only refer to the corporate standards, don't you, Mr. Hertz?
That's correct.
Now, I would like to guide us to the contract, which you seem quite aware of. Now, I would like to guide us to the page 61 of the contract, namely clause 8.2. Now, do you can you see it, Mr. Hertz?
Yes, I can.
Does it provide here that, does it set out 2 criteria for the guarantee?
I actually see, I'm not an expert at interpretation of the contract, but from what I can say, there are 3 requirements.
Mr. Hertz, this is quite a simple question. You do not have to be an expert to understand it. Could you name those 2 criteria, please?
I said 3 criteria.
2 criteria that are mentioned in the first sentence, please.
Counsel, Mr. Hertz said there were 3 criteria from his understanding. So maybe we can ask him to name what they are.
Sure, Madam Presiding Arbitrator.
Thank you. Mr. Hertz, please.
The first is that the guarantee shall comply with the market standards. Second is that it should be provided by a first-line financial institution. And third is that it shall comply with the model guarantee that is provided in the Exhibit A.
Mr. Hertz?
Sorry, Mr. Hertz and counsel, allow me to ask the question. You are clearly not a legal expert, but I think that you want to read something into 8.2, which I do not see. Reference is made to the need to comply with market standards and provide by first-time financial institutions. So shall comply refers clearly only to those 2 requirements. Then the way I read it is that you have added, or there is added a language referring to a model guarantee is provided. Would you please point out the language which requires the guarantee to comply with the model in that sentence? Because I do not see it. And you have been trying to be evasive. I understand that this is what many experts and witnesses try to be, but you have added now something, and I would like you to point to it.
Mr. Arbitrator, as you pointed out, I cannot interpret this statement, but what I can tell you is about our negotiations and about the intention with which the sentence was added
Sorry,
within this clause.
sorry, Mr. Hertz, no. You added wording into the contract which is not in there. Do you see that? Is this a yes or no question? There is no reference there. Then interpretation is a different issue, and whether the bargaining can come in, it's an issue of applicable law, and you clearly are not a lawyer. You mentioned this yourself.
I'm not.
So
Yes.
you have added language which we do not see in 8.2. This we can agree on.
Sure, Mr. Arbitrator.
Thank you.
You're correct.
Mr. Arbitrator, that was the question I was going to ask, but thank you for jumping in. My last question regarding this clause, and I hope that you will be answered it. Would the clause would modal guarantee even be, would there be a need to include an obligation to follow the modal guarantee if it is provided that the guarantee shall comply with market standards? Would it be necessary to even mention the second part, the market standard shall be followed? Sorry, would it be necessary to provide that the market standard shall be followed if the modal guarantee solely is to be followed?
Madam Presiding Arbitrator, if I may object to this line of questioning. Again, as Mr. Arbitrator has pointed out earlier, the witness is not a legal expert. He cannot tell whether it would be any other amendment to the clause would be required or how the clause should be framed. He can only speak as to the intentions of what he meant as the contract negotiator when he was negotiating this contract. He cannot comment on the phrasing.
Thank you.
Madam-
I agree, counsel. I think you have to be a little bit careful when you're dealing with legal documents and a factual witness, even though he is the chief negotiator, and even though your questions may be direct and simple, this is really a matter for argument before us and for us to decide at the end of the day. So unless you have other questions for this witness on his negotiations with his counterpart, I suggest we leave the wording of the contract aside. Thank you.
Thank you, Madam Presiding Arbitrator. That was actually the last question concerning the contract. But now I would like to refer us back again to the Exhibit C6, to the page, if I'm not mistaken. Yes, thank you, Mr. Krachmal. So, Mr. Hertz, do you confirm that this is an email where the guarantee was provided to you?
That is correct.
Now, and what is the date of this email?
11 June 2018.
Just for the clarification, it was Monday of that year. Now, I would like to move to your own witness statement. It is page 142, para 12, last sentence, please. Now, Mr. Hertz, could you please read that sentence?
Absolutely. As soon as AGB presented a conforming guarantee, we made the upfront payment.
Now, Mr. Hertz, could you please tell us what date did you make the upfront payment on?
From what I remember, I think it was 21st June 2018, but you can correct me if I'm missing out on something.
Yes, Mr. Hertz, your understanding is correct. So it took you 10 days after the receipt of that email to send an upfront payment. Is my understanding correct?
Counselor, I will also want to point out that within these 10 days, there were not 10 working days. There were, I think, 8 working days within which we had to do it.
Now, thank you. I believe that I'm fine. So just to clarify, almost 4 months, the construction works were unable to start. Is this correct, Mr. Hertz?
Correct.
Now, I believe that we would now touch upon the question of the environmental authorization before I pass the floor to my co-counsel. Mr. Hertz, according to the contract, the environmental authorization had to be obtained before the final completion date. Is this correct?
Could you please refer to the provision of the contract?
Yes, it's page 57 of the EPC contract. It is the definition of the environmental authorization or environmental permit. Scroll, yes.
I'm at the definition.
Now, and so does it say here that, sorry, it is a little bit down there, but just to not miss out time, as the person who touched upon this issue on your witness statement, do you confirm? Yes, thank you. Before the final completion date, is this correct?
Correct.
And it was also an obligation of TEPC, is my understanding correct?
Correct.
And the final date under the contract was 1st July 2019, is this correct?
That is also correct.
I would like to go to the page 70 of the case study, namely Exhibit C5. Mr. Hertz, do you recognize this email?
That is correct. I do.
Now, is this sorry, it was sent by the Environmental Agency for Renewable Energy. Is this correct?
That is correct.
And this is a notification of obtainment of the environmental authorization. Is this correct?
That is also correct.
Now, could you please simply read the highlighted part, please?
You may begin with your energy production activities in accordance with the enclosed permit.
Thank you, Mr. Hertz. And could you please take a look at the date of this permit? When was it sent?
12 June 2020.
Now, Mr. Hertz, is my understanding correct? The period between 1st July 2019 and 12th June 2020 constituted 347 days, to be precise.
Council, I'm sorry, I haven't made that calculation, so I won't be able to comment on that.
To clarify, was it almost a year? Was it almost a year between 1st July 2019 and 12th June 2020?
That seems correct, Council.
Thank you. I conclude my cross-examination and pass the floor to Mr. Martinyuk. He will proceed with the next issue.
Thank you, Madam President.
Yes,
May I proceed?
yes, you may.
Thank you. Mr. Hertz, let's move to the question line about the black blades. Mr. Krakmal, will you kind to refer us to page 142, paragraph 15 of the supplementary witness statement. Mr. Hertz, in your witness statement, you mentioned that the black blades were necessary for completion of the facility. Am I correct?
Councillor, may I request you to be a little slow? I'm unable to understand.
In your supplementary witness statement, you mentioned that black blades were necessary for completion of the facility. Am I correct?
That is correct.
Mr. Krakmal, will you be so kind, page 65, Exhibit C1. But in the EPC contract, we have only, please do, yeah, to footnote. We have only a footnote, and in this footnote mentioned if it's advisable. Is it true?
If advisable.
Thank you. Mr. Krakmal, please do some kind to 142 page, paragraph 15. Okay, and paragraph 15, yeah. Mr. Hertz, would you be so kind to read the second emphasized question, started from TEPC demonstrated?
The EPC demonstrated that it was advisable, as I explained to Taylor in an email.
Thank you, Mr. Hertz. Mr. Krakmal, please, can you refer us to Exhibit C23 on the page 95? C23. Thank you. Would you be so kind to scroll a little bit down? Yeah. Mr. Hertz, this is just mentioned email. Am I correct?
Sorry.
This is just mentioned email in your witness statement. Am I correct?
Yes, this is my email. Correct.
Okay. And this email is dated on 26th of April, isn't it?
It is.
Could you be so kind to read the emphasized sentence?
Sure. The Agency for Renewable Energy has brought to our attention some interesting reports on the benefits of including one black blade in the turbines as a way to prevent birds from being injured or killed during the operation of the farm.
Thank you. But I was going to say highlight, but still. Mr. Krakhmal, would you be so kind to scroll a little bit up? Within the same day, you received an answer. Do you recognize it?
I do. This is Taylor's email to me.
Thank you. Could you read the first paragraph? It is highlighted by purple.
At this time, I don't believe we will be taking this approach to avoid avian fatalities.
Thank you. Mr. Krakhmal, page 155, exhibit R8. Would you be so kind? Thank you. 1 week later, you received the follow-up email. Do you remember it?
I do.
Please read the paragraph 1. It is highlighted by gray.
I have forwarded your request to the team and they don't think that this would be an effective solution.
In this email, Taylor informed you on objections of the local community. Am I correct?
Yes.
And moreover, they informed you about the conflict in Genova resulted by the black blades. Am I correct?
That is correct.
And moreover, they provided you information about the survey conducted in the Westerly. Am I correct?
That is correct.
And moreover, it's not only Westerly, but exactly Queen Landing, which is located in the Durham city. Am I correct?
Sorry, I couldn't hear your question.
And it's not only the Westerly, but the survey was conducted exactly in the Queen Landing, which located in the Durham city. Am I correct?
I am sorry, there seems to be some connection lag from your end because you're not very clearly audible.
This survey was conducted not only in Westerly, but exactly in Durham city. Am I correct?
Could you point me out to the fact where it says that?
Would you be so, Mr. Krakhmal, sorry, Mr. Hertz, would you be so kind to start the reading sentence from Queen Landing?
If I may object to this line of questioning, I believe the council is asking Mr. Alex, who is merely a recipient of this email, whether or not the survey was conducted. If I'm not wrong, the survey was conducted by AGB. I do not understand how would Alex be able to confirm where the survey was conducted.
Council, allow me to correct. I don't think that was the question. The question was not whether it was and the outcome, it was whether a reference to that survey at Queen's Landing is included in the email received by Mr. Hertz. And I hope Mr. Hertz will say yes, because that will allow us to go forward, because it clearly refers to that in the email. Mr. Hertz, would you answer the question?
Thank you for the clarification, Mr. Arbitrator.
Absolutely, Mr. Arbitrator. Queen's Landing is included, but I'm not sure if that was the question of the councillor.
I think council did actually refer to Queen's Landing and the city of Durham, where it is located.
Thank you, Mr. Arbiter. Mr. Hertz, would you be so kind to read the summary of this survey? It is started from the purple, however, 55%.
However, 55% of the population objected to the construction if one blade was painted black.
Thank you. And you have never mentioned in your witness statement about the reply of AGB on your request to paint black. Am I correct?
I have not done what?
You have never ever mentioned this fact about the reply of AGB in your witness statement. You have never mentioned this fact. Am I correct?
I think so.
You have never mentioned this fact even in supplementary statement. Am I correct?
I've not mentioned it in my supplementary statement.
And moreover, your request were made the 2 months before the deadline of the construction. Am I correct?
2 months. Council, how is it?
Would you be so kind to refer us, Mr. Kamal, to the C23? It is 26th of April. Is it 2 months before the deadline of construction? Am I correct?
Council, the construction was to be completed on 1st July 2019.
No, I'm talking about the construction according to the EPC contract.
According to the EPC contract, the construction was to be completed on 1st July 2019. This is 26th April 2019.
There is 2 months difference between this date. Am I correct?
Correct.
Mr. Krakmal, would you so kind to refer us back to this email? Sorry, not to email, to the just mentioned. Thank you. And would you scroll down? Mr. Klaus, would you so kind to read this purple, not purple, but pink paragraph?
So, finally, at this time, taking on additional work would mean more time and money. We would have to source the weather-resistant black paint and hire technicians who would have to travel to the site to perform the work. We cannot afford this kind of additional cost or further delays at this stage in the project.
Thank you. Thank you very much. It was my last question because my time is end. Thank you very much.
Thank you.
Thank you. We're now moving on to the. Are there questions for this witness from my colleagues?
No, thank you.
No, Professor Mistelis? Nothing?
Not for me, thank you.
Thank you very much. All right, thank you very much, Mr. Hertz. Is there any redirect?
Yes, Madam Presiding Arbitrator.
Please.
Right. Mr. Hertz, the respondent counsel questioned you on the negotiations regarding the deadline of the contract. Can you elaborate?
Yeah, sure. So Mr. Joule readily agreed in our oral conversations to a 400-day deadline. And at that time, whatever was our discussion was clearly reflected. Whatever we agreed on was clearly reflected within the contract. So the assurances that they are mentioning, which are not in the contract, are something that I don't think are applicable.
Okay. Can you elaborate what happened with respect to the upfront payment as you were questioned in the cross?
Yes, sure. So in the contract, at the time of the negotiation, it was very clear to us that the reason why we were putting that exhibit was to represent the market standards, and so that there's some understanding of market standards at that time. Now, we did not get the proper guarantee as per the market standards, which also aligned with the exhibit to which we were referring to. And
I'm sorry, Mr. Hurt, if I interrupt you, but earlier you did say something a little different, and I would like you to clarify. Because now you refer to the fact, indeed, as the contract seems to reflect, that the attachment merely is a model that reflects market standards, while earlier you did expressly say that, and this was when I questioned you at one point, that the contract required you to use that attached model. So there are two different things, and you have contradicted yourself now. So no, also, yes, because earlier on my question, you clearly said something else compared to now. Would you please clarify what you meant to say either earlier or now?
No, Mr. Arbitrator, I do not believe that I have contradicted myself, because to be clear, it's not a question of how many requirements, but what are the requirements. And to say that market standard requirement is the same as having that exhibit as the requirement, is one requirement or not, is, in my opinion, not very relevant. The fact that, in my opinion, both are the same requirement or both are required is what matters, in my opinion.
No, this is not what the contract says. And fortunately, you have told us just when at the beginning of the redirect that everything you have to agree on is in the contract. I do not see the contract saying what you said earlier. I understand, of course, that you wanted to give some sample of market standards, but it is different from saying that that specific model has to be used. Thank you. Council, you.
Thank you, Mr. Presiding Arbitrator, or Mr. Arbitrator. I do believe this is the contention just managed is actually a legal argument that is included in a skeletal briefs. I believe the tribunal can examine it in the next stage of proceedings. Continuing, Mr. Hertz, counsel questioned you on your reply when Taylor first sent you a draft guarantee. Can you elaborate?
Yes, sure. So I did reply on 1 day delay, but it was merely because my legal team had to review the template as the template according to the contract needs to be followed. And had the template followed what the contract had said, we would have replied immediately and provided the upfront payment.
Can you elaborate on the model guarantee that had been attached in the contract?
Yes,
Objection.
sure.
The opposing counsel himself has said that his client is not an expert on this matter. Now he clearly requests him for his.
If I may rephrase.
Counsel,
I'm sorry.
Counsel, let's
Just
be very
second,
civil.
one second. We can only speak one person at a time.
Exactly.
Apologies.
We have to hear the objection in its totality, and then if you disagree, counsel for the claimant, you can tell us. So please, Ms. Kirichenko, please, what is your objection? You said the question calls for legal expertise. Is that your objection?
This is my objection.
My apologies, Madam Presiding Arbitrator. If I may rephrase, Mr. Hertz, I'm not asking for a legal opinion. Can you just tell us the contract discussions that happened regarding the model guarantee? The facts.
Sure. Absolutely. So we discussed that the model guarantee, and we agreed on it as for what I remember during our negotiations. This is also clearly in my understanding, because we have been using the same model guarantee in all our contracts to ensure that this issue does not arise.
You are also questioned on the environmental authorization to be provided by TPC. Do you want to elaborate?
Yes, I do. So the council showed me the date on which the final environmental permit was approved by the agency. However, the environmental authorization required for construction of the contract was merely a temporary permit that was required, and we had even filed that for that permit before the contract was signed, and we had it. So it did not cause any disruptions in the plans of AGB to construct the project.
Right. You are also questioned on what the contract says on black blades. Can you elaborate?
Yes.
The facts.
Yeah, sure. I can elaborate. So it was, so as the council showed that within the contract, it's written if advisable. And we meant to believe that if we advised them that the black blade was, one blade was to be painted black, they would confirm, because they are the contractors and we are the owners. So it made sense for us that the advice would only be our advice and it wouldn't matter what they would say. So in my opinion, since we advised that they should paint the blade blacks, they should have done that, and that became a requirement under the contract for them.
My final question to you, Mr. Hertz. The council has throughout his cross-examination highlighted that you did not reply to certain emails by AGB. Can you elaborate, like, what did you mean by that? Those omissions, were there an acceptance? So, just elaborate, please.
No, they were in no way any kind of acceptance to any of the emails that they had sent. This project has been going on for a long period of time, and we had been doing a lot of work. So it's plausible that I missed a few emails here and there, but that does not mean that there was any kind of amendment to the contract. The provisions and the procedure under the contract remain the same.
Thank you, Madam Presiding Arbitrator. With this, I conclude my redirect examination.
Thank you very much. Is there, I don't expect there to be recross, but please tell me if I'm wrong.
I have, before we go to a recross, I have a short question for the witness. Mr. Hertz, as a commercial manager, how often are you involved in contract negotiations?
Mr. Arbitrator, quite often.
And do you take a role in the actual drafting or wording of contracts?
Mr. Arbitrator, I usually have my legal team with me who make sure about the wording of the contract.
Okay, so your main role in such discussions and negotiations is to ensure that the commercial deal works for your side.
Absolutely, Mr. Arbitrator.
And the final question I have, because you have referred, we have discussed quite a bit about market standards. Are these financial market standards, or are these industry market standards, as in sort of EPC contracts?
Mr. Arbitrator, I understand them to be the industry requirements.
Okay, thank you. Thank you very much.
Thank you. Recross from the respondent side.
Yes, Madam Presiding Arbitrator. Now, I would like to first ask you, is my understanding correct? There is only one market standard for the model guarantee, and it is only reflected in your corporate standards. Is this my understanding from your reply to the arbitrator, Professor Ferrari?
That is correct.
Thank you for this answer. And now I would also like to ask you about, you said that the temporary guarantee was enough. Is my understanding correct? Correct. Now I would like to, if honorable members of the tribunal do not mind, this is the notice of dispute of TEPC. Do you recognize it?
Yes, correct.
Now, could you please read out the highlighted part?
Yes, sure. In any event, since a temporary permit was granted to allow construction, while the final permit was processed, the delay in obtaining the final environmental permit could not have impeded AGB's progress.
Now, could you please tell me what was the purpose of the temporary permit according to this sentence?
Counsel, what do you mean by the meaning of temporary permit according to this sentence? Because temporary permit, if I understand correctly, has been detailed in one of the clarifications.
I will paraphrase for you. Was the temporary permit granted to allow construction?
That is correct.
Now I would like to guide us back again to the to the environmental authorization, C5, page 70.
Counsel, how does this, I'm sorry to interrupt you. How does this refer to something that arose in redirect? I'm not following you. I could have missed something.
Madam Presiding Arbitrator, Mr. Hertz has stated that there is no difference between the final authorization and the temporary authorization. He said that there is no difference, and now I'm trying to understand, is there any difference or not?
Just one second. I think Mr. Hertz is disagreeing with you. Just one second, please. Mr. Hertz was shaking his head. Is there a difference or isn't there a difference, Mr. Hertz?
Madam Presiding Arbitrator, that was not my statement at all. There is, in fact, a difference. And the difference is that the temporary permit allows for the construction of the project, whereas the final permit is required for operationalization, as is also clear from the record clarification number 4 and clarification number 7, from what I remember.
Thank you. Counsel, does that help?
No, actually, Mr. Hertz, does it reflect what you have previously stated? I clearly do not recall you saying that.
And allow me to add, and this is Arbitrator Ferrari speaking. In fact, Mr. Hertz has actually not said so. Mr. Hertz has indeed only stated that the fact that there was a temporary permit would allow construction and would not lead to delays. That's the only statement. So no distinction had been made by Mr. Hertz. Unfortunately, we don't have the benefit of the transcript but I'm sure the transcript would reflect this.
All right, and Mr. Hertz, let's go back to the email C3, where you have discussed the conditions. Now let's go a little bit down to this email, and could you please read here the part where you please a little bit down so we can see the next part of the page. And could you please read the sentence that is not highlighted, but I'm confident, and just move on. Could you please do so?
The one highlighted with the mouse right now. All right.
I'm
confident. I'm confident that this deadline is feasible in view of your expertise. Please let me know if there are any contractual accommodations that will make this deadline work.
Now, and in reply to this email, did Taylor Jewell provide you with such accommodations? Is my understanding correct, Mr. Hertz?
That is correct.
Now, so it was the email where Mr. Jewell has accepted your proposition for the deadline.
That is correct.
And was it the first email where he described those conditions, right?
Which conditions?
For meeting such for accepting such a deadline.
Are you talking about the exceptions that are reflected in this email?
If I may object, can I ask the council to please clarify how is this connected to the redirect? I'm very sorry.
I have the same question, actually. Ms. Kirichenko, please.
Yes, this issue was touched upon in the redirect. This email was discussed there. So what I wanted to clarify, Mr. Hertz.
I'm very sorry. There was a lag. Please continue.
Sorry. So, Mr. Hertz, just to clarify, was it the first email, and was this email later on the template for the future negotiations of the contract? So, was this email essential for the future discussions of the contract, or was it not?
Madam Arbitrator, I'm not sure if the objection has been decided by the tribunal and if I should be answering this question.
So your counsel, I think your counsel is no longer objecting. Am I right?
Ma'am, I'm sorry, Madam Arbitrator, I am objecting because I do not remember discussing this email at all. With regards to email, I only remember my question being whether Mr. Hertz lack of response to any email meant anything to him.
Yes,
that's it. I did not discuss any specific email.
Very good. So, Ms. Kirichenko, I tend to agree, unless you can point me to a specific discussion about this email that your question arises out of. I mean, the fact that this email was generally discussed in redirect is one thing, but it has to arise. Your recross has to arrive from something that came up in redirect, and I'm not seeing that. I could be missing something.
Madam Presiding Arbitrator, Mr. Hertz has said that this email was unimportant because later on the other conditions were agreed on. And what I was trying to say is that this email was essential and later on followed in the negotiations of the contract. This is what I was trying to say, but I see that my time is running up. So if you do not mind, I would conclude my recross.
Thank you very much. All right, I think we're done now with Mr. Hertz. Thank you for being here. And we're now moving on to Mr. Jewell. Is that correct? Am I right? Is that the right sequence? Yes. Thank you.
May I start?
Yes. Oh, there you are. Okay. Thank you, Mr. Jewell. We're going to have to ask you, please, to take the solemn affirmation, which is in the chat.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
That's very good. Thank you very much. Council, please proceed.
Honorable members of the tribunal, counsel for the claimant, witnesses, and other participants. Good morning or afternoon, wherever you are. My name is Roman Krokhmal, and I'll proceed with a direct examination. Silot Martinyuk would assist me if it's needed. Hello, Mr. Jewell.
Good day.
Please state your name for the record.
My full name is Taylor Joel.
Is there anything you wish add or change in your witness statements?
I have nothing to add.
Do you confirm that your statements is true and correct to the best of your knowledge, information, and belief?
Exactly.
Do you have a case file in front of you?
Yes, I do.
Please share your educational background at first.
Well, I have a degree in international business from Estes University with exactly the focus on energy sector.
And what is your current position at AGB Construction Enterprise?
I'm the commercial manager.
And what was your role in Dorm Wine Farm project?
Okay, I mainly was in charge of negotiations of EPC contract and communications with Thomas Edison Power Corporation.
What was the initial deadline proposed by AGB?
It was 500 days.
But in contract included 400 days deadline. Could you please describe this matter in more details?
Sure. Alex Hertz proposed me to reduce the deadline by 100 days, and I was slightly surprised about it. But we as AGB warned him that we would like to include the flexible force majeure clause in the contract, and also we need their local expertise in regulatory matters. After that, we finally agreed to the reduction of the deadline.
After the moment of signing the contract, were there any problems?
Sure. We were unable to start the work for almost a month because the EPC did not make the upfront payment on time. It declines our guarantee because they were not in line with their corporate standards, although nothing in the contract provides so.
And was it the only problem?
There were some of them, to be exact. TEPC refused to help us in obtaining the import license for the highly specific coating.
And when did TPC request to apply that coating?
In August 2018, as far as I remember, several months after the signing of the contract.
And what problem did you face regarding this issue?
It was very hard exactly to find the supplier of this coating, but we managed to do it. It was a little known TEC1 solution from Genovia. Unfortunately, Versailles imposed sanctions on it, so we need to obtain the import license, which took a lot of time.
Have you asked Alex Hertz for help in that problem?
Yes, in the December of 2018.
And how he answered?
I was surprised because Alex Hertz said that that TPC had no expertise in import regulations. Also, he said that processing of the import was not his part of this project.
Let's move to the question of black blades included in witness statements. Was there any discussion about including this feature in the contract?
We only agreed with Thomas Edison Power Corporation that it would be that the reference to it would be included in the footnote in annex to the contract, citing that this approach would be taken if it were advisable. That's all.
And my last question. Were there any requests from any authorities to perform the painting?
If you're talking about the government obviously never requested the blades to be painted black.
Thank you. I conclude my direct examination.
Thank you very much. Who is it cross-examining for the claimant?
Madam Presiding Arbitrator, I will be cross-examining the respondent.
Very good. Thank you.
With your permission, may I begin?
Yes.
Thank you. Mr. Taylor, could you tell me about your role in AGB?
I said that in my direct examination. Exactly, I'm responsible for the I was responsible for the negotiation of the EPC contract, and in AGB, I'm responsible for the contracture of the commercial matters, business matters, and communication. Sorry. Did we have something with connection? Because
I think yes, you look like you've frozen up. Is it Mr. Darsan?
Madam Presiding Arbitrator, am I audible now?
Yes, please carry on.
Apologies for the technical difficulties. Mr. Jewell, I was asking whether you played a very serious role in the negotiation of this contract in the Dawn Wind Farm project.
Can you please repeat the question? It's I didn't
you
understand.
played a serious role in the negotiation of the Dawn Wind Farm contract, correct?
Yes, it's correct.
Let us move on to the question of delay that you mentioned in your written statement. You have stated that TEPC's request for a specialized coating was one of the reasons for the delay, correct?
Not exactly the request of such exactly specific coating. Yes, it was the cause of this delay because it was the sanctions and we should obtain the IMBR license, which very delayed the process.
Now, TEPC sent the specifications of the coating in August 2018, correct?
Yes, several months after the signing of the contract, correct.
I would like to draw your attention, Mr. Jewell, to exhibit R10 on page 157. My co-counsel will be sharing that on the screen momentarily. Could you kindly read the highlighted portion out?
Yes, 1 second. I only, yes. Sorry.
Mr. Jewell, we can't hear you. I think you've lost your connection. Hello?
Sorry, I had something with connection.
Yes, you're back now. You're back now. You disappeared for a moment. We didn't hear you read the highlighted portion, so perhaps you would do that. Thank you.
Sorry, for the sake of clarity, can the council for
Right, you're gone again. Mr. Jewell, your connection has dropped.
I think
now
it's
back. Now you're back.
It should be right now. Yeah. Sorry. I'm very sorry.
What did you want to ask? What did you want to ask, counsel?
For sake of clarity, can the council show me what is exhibit and what is the mail at all?
Certainly, Mr. Jewell. This is exhibit R10. This is a mail that you sent on 16th August 2018.
Yes, I remember. Thank you.
Could you please read out the highlighted portion?
Yes. We still have time to order a more specific coating that complies with this new specification, but it would mean additional costs and work.
Thank you, Mr. Jewell. Now, you discovered TechWind Solutions in December 2018, correct?
It's correct, yes.
I would like to draw your attention in that case to exhibit R12. This is my co-counsel will be putting that up momentarily. Now, this is the executive order that imposed the sanctions on Genova. The highlighted portion reflects the date on which this document was issued. Could you read that out?
Sorry, the highlighted portion?
Yes.
The 30th of October 2018.
At the time you selected TechWind, then the sanctions were in force, correct?
Can you repeat, please? I don't understand.
At the time that you selected TechWind Solutions in December, the sanctions were already in force, correct?
Yes, it's correct.
Between August 2018 and December 2018, you did not ask TEPC for details of other companies that provided this voting, did you?
Sorry, did I understand you correct? You said that did we ask for the other suppliers which TPC had to
Yes, Mr.
inform
Gill, you
us?
understood that correct.
Sorry, but it's not our burden because under the contract, as far as I remember, we had to action. All our action should have the good faith efforts. So if you're talking about if we ask TPC, no, but it was the burden of TPC to provide us with their suppliers because exactly TPC requests that specification.
Mr. Gill, thank you for your detailed answer. In the future, may I kindly request you to keep your answers brief in the interests of time? We will be able to proceed with the cross-examination better in that way. In paragraph 14 of your witness statement, Mr. Joule, on page 221, you are stating in the highlighted portion that you were surprised when Alex informed you that processing import permits was not part of their role in the project, correct?
1 second. Yes. I'm said this in my direct also.
Mr. Joule, I would like to draw your attention in that case to paragraph 5.4 of the contract on page 59. I have highlighted a portion. Could you kindly read that out for me?
Out loud?
Yes, please.
Okay. Contractor shall be required to obtain all other authorizations, import and export permit required for the performance of the work.
Mr. Joule, we shall proceed to the environmental permit that you mentioned. You have also stated that TEPC caused a delay by not obtaining the final environmental authorization on time, correct?
Please, sorry, can you, what TPC did?
You have stated that
Yes.
one of the reasons for delay was that TEPC did not obtain the environmental authorization on time, correct?
Yes, it's, sorry, can you please, only for formulation of, only, I'm just don't remember the formulation of the statements. I have to concretize about this formulation because I don't remember exactly the delay.
Mr. Joule, I shall restate my question. In your opinion, did TEPC contribute to the delay by not obtaining the environmental authorization on time? Yes or no?
It failed to obtain their authorization on time. Exactly. He did not obtain this authorization by the completion date. So exactly, it's contributed to the delays.
However, I would like to draw your attention to Exhibit C5 on page 71. According to this document, which is the final environmental permit, this states that TEPC had obtained a temporary permit in May 2018, correct?
Yes, it's correct.
I would like to draw your attention once again to point 4 of the clarification. It states that a final permit, environmental permit, is only required for the operation of the plant. If you bear with me for a moment, my co-counsel will be putting that up. very shortly.
Sorry, what is the document? I'm just
This
didn't
is
remember
the
from the bundle.
clarifications in the bundle, correct?
I just don't remember that in the bundle. Okay. Should I read
Could
it?
you read out the second highlighted portion?
Okay. The permanent environmental permit is necessary to operate the wine farm. Yes,
According to the
it's
first highlighted portion, a temporary environmental permit allows the construction to begin, correct?
Yes, the temporary permit allows the construction exactly, but without the environmental permit, the construction cannot finish, and the facility cannot be running without the environmental authorization. I think it's clarified.
Mr. Jewell, AGB was contracted to construct the wind farm, correct?
Sorry, I just don't understand your question.
AGB was contracted in this case to construct the wind farm, correct?
The main purpose of the EPC contract, yes.
AGB was not contracted to operate the wind farm, correct?
No, exactly.
Before a final permit is issued, there are on-site inspections that are required, correct?
I have no such information, sorry.
I would like to draw your attention in that case once again to clarification number 7, which is on the record.
Objection, Honorable Tribunal.
Yes.
It is more procedural case because after all the clarification, necessary amendments were mentioned, necessary edits were made in the case file. That's why I would like to ask the opposite counsel to refer exactly to the case file. That means all this information were included in the case after modification.
Madam Arbitrator, this document constitutes part of the record. This was released officially by the organizers. I believe that we should be allowed to refer to it.
Yes, I thought as well that this was part of the file. Mr. Martiniuk, are you saying this is not a document that's part of the file? Is that the basis for your objection?
I'm telling that after the clarification, the organizers provided the case moot court case file with clarifications in another document, and all this clarification included in the case file. It is really important to understand the context for witness. That means I would like to ask.
I understand. So, what your objection is that you want Mr. Darsan to give the witness some context to this document?
Yeah.
Okay, Mr. Darsan, can you do that, please? Well, it's been done now, I guess, but if you can just explain to Mr. Jewell what, you know, under what circumstances this document was issued.
Madam Arbitrator, I think this document was issued after clarifications requested by other teams. I do not think that this was in the context of the problem itself. I think what the respondent counsel was referring to is that in some cases where there were errors in the record, those errors were rectified in the main document. But this clarification directly has not, as far as I'm aware, been included or modified anywhere, since this was simply a clarification requested.
Thank you. Mr. Martiniuk, is that sufficient for your to address your concern?
Yes, Madam President.
All right, very good. Please carry on, Mr. Darsan.
Thank you, Madam Presiding Arbitrator. Mr. Jewell, according to this statement, a permanent environmental permit is issued after an onerous examination of the wind farm, including on-site inspections, correct?
It's correct, yes.
So you cannot perform an on-site inspection when nothing has been constructed, can you?
I have no relation to such activities, so I can answer to this question, to be honest.
Mr. Jewell, in June 2019, was the wind farm near completion of the construction?
Sorry, what's a month you said?
In June 2019, was the construction of the wind farm near completion?
No. So I just want to.
Mr. Jewell,
clarify? I just want to clarify
I
because
would-
it's only my mine, but I'm not an expert in the question because this question of construction. So you should attribute it to the chief of works, Mr. Watts, my colleague, because I'm working from my office, not in the site. So I can only presume that no or yes, but exact facts I cannot provide you such information. Sorry.
Mr. Joel, once again, I would request you to keep your answers brief and only answer yes or no. If you do not know, kindly state that you do not know and save your explanations for the reader. If I may restate my...
whether the witness answers yes or no rather depends on how you ask your question. Now, if there is some context to Mr. Jules that he wants for the tribunal to have an accurate reply, he should be allowed to say it. Where I will agree with you is that he doesn't have to get into a very complicated explanation that has nothing to do with the answer. But I don't think that's what he was doing here. Thank you.
Thank you, Madam Presiding Arbitrator. I shall keep that in mind while proceeding. Mr. Jewell, I understand that you were not on the farm during the constructions. However, you are aware of when the certificate of completion was issued, correct?
The certificate of completion was issued in the 2020, not in 2019.
So by 2019, the construction would not have been completed, correct?
I can only say that it was not completed. In what stage? Sorry, I cannot answer. I have no further information.
Thank you, Mr. Jewell. I would like to proceed to the issue of the black paint. In this regard, may I refer you to Exhibit C5 once again? My co-counsel will be putting that up shortly. This is a letter from the Agency for Renewable Energy, correct? And this is the document where the final permit was issued.
Sorry, I don't recognize exactly that.
Objection. The witness is not the one in the copy or is not the addressant on this exhibit.
I think, Mr. Darsan, maybe it's worth asking Mr. Jewell whether he is aware of the existence of this and he's seen it before.
Thank you, Madam Presiding Arbitrator. Mr. Jewell, you are aware of the environmental permits that were provided in this contract, weren't you?
About the environmental permit? Yes, exactly. I was aware about it.
Mr. Jewell, this is the final environmental permit application, and this has been issued by the Environmental Agency for Renewable Energy, according to the signature, correct?
Objection. This is not the document. This was an email to Mr. Toppler. The document is below. Please.
So, okay, Mr.
Madam
Jewell.
Arbitrator, if I may rephrase my question in that case.
Yes, I mean,
apologies.
May I ask counsel to avoid speaking over an arbitrator? That's the first rule, I think, in arbitration. Second, to allow opposing counsel or anybody to first finish his or her sentence.
Thank you, Madam. Mr.
Yes, Mr. Darsan, please. I think I'm going to cut through this a little quickly. Mr. Jewell, have you seen this document before, the letter or the document underneath?
I have analyzed the all documentation before my hearing. So probably I had some, yeah.
So the answer is yes, you have seen this document. Sorry.
Recently, yes, I had seen this document.
Okay, so you're able to answer Mr. Darsan's questions on this document.
It depends on the
Depends on the question, fair enough. Okay, Mr. Darsan, please ask your question, and if Mr. Jewell knows the answer, he will give you.
Mr. Jewell, this letter was issued by the Environmental Agency for Renewable Energy, correct?
Probably yes.
Yes or no, Mr. Jewell?
Okay, yeah, yes.
Thank you. Could you please read the highlighted portion for me? Out loud.
Okay. Please bear in mind that the permit may be withdrawn in case of any non-compliance with the applicable environmental regulations.
Thank you, Mr. Jewell. I would like to draw your attention to exhibit C22, which is on page 94 of the record. C22. This document contains the minutes of a meeting dated 20th March 2018, correct?
Yes, I am on the attendance.
Yes. If my co-counsel would scroll down a little, according to one of the items that were discussed, one of the points related to avian safety, correct?
Yes, these points were discussed.
And you discussed the monitoring procedures for avian fatalities in accordance with the Endangered Birds Act, correct?
We discussed it, yes.
And you also discussed on the issue of the painting the blade black, correct?
Yes.
I would like to bring your attention then to exhibit B in the contract, which is on page 65. Could you please read out the highlighted portion?
Exactly. If advisable, at least one blade shall be painted black.
I would like to thank you, Mr. Jewell. I would like to draw your attention to exhibit C23, dated 26th April 2019. In the first line, Alex states that the Agency for Renewable Energy suggested reports about the benefits of a black blade to prevent birds from being injured, correct?
Just a second. He said this. Yes, I remember.
And in the next line, Alex states that he wants to heed to the advice of the agency, correct?
Sorry, can you repeat?
Apologies, the highlighted paragraph, the highlighted section is incorrect. The one that is highlighted with the mouse presently. In this statement, Alex wishes to heed to the advice of the agency, correct?
It's correct.
I would like to move on to the issue of the extension. In paragraph 17, page 222 of your statement, you state that TEPC agreed to an extension, correct?
Yes, yes, it's correct. We had a call in the May when exactly we proposed and they agreed. It's correct.
And then paragraph 18, you indicate that TEPC only became inflexible after the tariff scheme was modified in January 2020, correct?
Yes, I mentioned it. It's correct.
I would like to draw your attention to exhibit R2, which is a mail dated June 4th, 2019. This is a communication from you to Alex Hertz, correct?
It's correct.
Mr. Jewell, in this statement, in this email, you have not referred to any definite period of extension, correct?
Just give me a second. Yeah, I can give you my explanation about it.
Mr. Jewell,
we discussed the extension with TPC, and even Tristan Topler said that he granted the extension to the early 2020. He said that in his witness statement, as far as I remember, and we thought that this means that the original deadline is flexible and it's no longer feasible. That's what we thought.
Mr. Jewell, this email does not contain a response, correct?
I had a very great amount of emails, so I don't remember. Bro, it's
in
mail
the
from
record
me?
attached. Yes, in the record attached, this mail has no response shown, correct?
Yes, exactly. TPC ignore this email, correct?
I would like to draw your attention to exhibit C4 on page 69. This is an email to you from Mr. Alex Hertz, correct?
Yes, it's correct.
And this is dated 31st July 2019, a month and a half after you sent the previous response, correct?
Yes, but the subject of this email is different.
Mr. Jewell, this email does not make a reference to the extension at all, correct?
Sorry, can you repeat?
This email does not refer to an extension, correct?
1 second. No, oh, sorry. This email was after we agreed. So yes, it's nothing about the extension because the subject of this email, it's not about the extension. It's the email with a different substance.
Mr. Jewell, in this email, I would like you to read the paragraph above the second highlighted statement. It reads, could you kindly read that starting from "we were under the impression"?
Yes, we were under impression that after our conversations about the deadline, AGB had made the necessary adjustments to meet the contractual terms. The importance of the deadline has been stressed to AGB at every time.
Mr. Jewell, this email was sent to you 6 months before December 2019, correct?
Sorry, six months before.
This was before December 2019, correct?
Yes, correct.
Thank you, Mr. Jewell. I think, Madam Presiding Arbitrator, I have exceeded my time at this point. In that case, I would like to rest my examination for now and proceed with the request at a later point in time.
Thank you very much. Redirect, please.
I may start and then put floor to the Vsevolod. Okay. Please, Mr. Jewell, tell us what was the importance of final environmental permit?
It is probably the most important permit because without the permit, no one can run the facility and the facility cannot produce the energy. So it is not a probability, and without the final permit, we cannot find the completion date, and all the works cannot finished. I just want to clarify that all the works cannot be finished without final environmental permit, because without it, facility is not operable. That's the fact, I think.
Okay, I'm moving to the question of black blades. Was there any written recommendation from
Council, may I ask a question to Mr. Jewell? So, opposing counsel, when cross-examining you, did hint at the fact, and I think we know that there is a difference between the temporary permit, because it relates to construction, as we know now from both witnesses actually, and the final one relates to operation. So couldn't one say what your company was actually to do, and I think this was hinted at by counsel for opposing party, was just to construct it. Whatever opposing counsel then does is opposing counsel then does is for that client to decide. The client could say, I like it, it looks nice, to me it's beautiful, I leave it there and just want to look at it. So what would you think of that? Aren't these two different permits? You have to do one thing, whatever they do with the result of your construction, it's up to them.
Yes, I explained my point about it. Without the environmental permit, the works cannot be finished, because under the contract, we should construct the state of the art. So the facility cannot produce the energy. And yes, we construct, but we cannot finish the construction because the facility is not has not produced the energy yet. So without this permit, we cannot finish. We cannot construct, but this wouldn't be the completion date of this construction. I think.
May I proceed?
Yeah.
Okay, Mr. Jules, I would like to ask which type of permit necessary to connect the construction to the local grid of the energy net?
Another, it's also, I have no relation to these activities, but Ali Watts instructed me that to connect to the local grid, we should have final permanent environmental authorization.
Thank you. I would like to refer to the question of the black blades which were rising. That means the opposite council raised the question of the black blades and they want to discuss it now. I would like to refer to, sorry, it is not allowed to me to share my screen. Would you be so kind to may this, thank you. The exhibit C23 on, yeah, C23. Mr. Jules, would you be so kind to elaborate more about your answer on the request for black blades?
You're talking about only this email or my whole answer?
Both emails.
Okay. Mr. Hertz emailed me that Renewable Energy Agency advising him to paint the black blades, but we have no proofs about it, only his email. So before the construction, the survey was conducted about this issue. The study, we back up our position with a study in the case, and it was obvious that I exactly answered in a mail, Mr. Hertz, that it is not advisable to use this approach. And I follow up even my first email with, yes, exactly this email about the results of the survey, which was conducted, as I mentioned before the construction has begun, in the streets in the dorm city. And as we can see, 55% of the population objected to the construction if one blade was painted black. And we had an experience of that in our previous projects with Genovia, where it's really performed for us some problems with X in the side. So it was obvious that this footnote uses only in the way that the painting blades is not advisable.
Have Alex Schwartz ever reached you to object this research or this feedback or your answer?
Mr. Hertz has never raised any objections about this answer, so I think I thought that we agreed on the matter.
Thank you. And have they ever raised any objection in the time of the completion certificate, or do you obtain any objection from the environmental agencies or etc.?
As far as I remember, the employees of TEPC had the access to the site before granting the certificate of completion. And the certificate of completion said that the construction was completed in accordance with the plans and specifications. So I think there is said that there is no objections at all, and all was with the plans.
Thank you, Mr. Jules. My time is up.
Thank you very much. Recross? Is it Mr. Darsan again, or?
Madam Presiding Arbitrator, I will be conducting the recross as well.
Thank you.
Mr. Jewell, in your redirect, you stated that all the works cannot be completed without the final permit, correct?
The facility cannot be finished without the final permanent environmental authorization, correct?
I would like to draw your attention to a communication dated June 2020, which my co-counsel will be putting up very shortly. Apologies, Mr. Jewell. We shall be putting the document up very shortly.
I'm asking for the tribunal. We can provide help if you decide the opposing party can just name the exhibit.
Thank you very much for your assistance, Mr. Counsel. If I may ask Mr. Jewell, by June 2020, the construction works was nearly completed and was ready for electrical commissioning, correct?
By 2020?
By June. Yes, by June 2020.
Yeah, yes, it was nearly completed, correct.
Mr. Ferrari, I noticed that you had your microphone. Were you going to intervene?
No, sorry, that was an error. Thank you.
Apologies. Mr. Jewell, the certificate of, I would like to bring the exhibit up for your reference. On June 1st, 2020, a mail was sent to indicating that things are ready on our end to begin the electrical commission, correct?
Excuse
Sorry,
me.
is there an
I would
objection?
like to, yes, there is an objection. As you may see, witness is not in the copy of this email. Could you please provide the relevance?
So, Mr. Darsan, we've had this objection before. When you are putting documents in front of Mr. Jewell where he's not mentioned or apparently has not had sight of, you have to ask him if he's aware of this document, if he has familiarity with it. Otherwise, it's pointless.
Certainly, Madam Arbitrator.
Thank you.
Mr. Jewell, were you aware of the dates of the electrical commissioning project?
About the dates?
Yes.
Sorry, but no, I'm not aware about the dates.
This communication was sent to Ali Watts, who is the Chief of Works at AGB, correct?
Yes, it's correct.
And from this email dated 1st June, Mr. Tepler is indicating to Ali Watts that electrical commissioning can begin, correct?
Sorry, I don't feel that I should answer to this question because I have no relation to the electrical commissioning. It's only the responsibility of Ali Watts. I even cannot presume exactly the process of electrical commissioning. I only know in general ways what is it. So can you please can you please rephrase your question or say to me what you're talking about exactly?
Mr. Jewell, I understand. I shall rephrase my question. My question is simply whether on 1st June, TEPC indicated to AGP that the electrical commissioning process could begin. I'm not asking for any other details, but merely from the highlighted portion. They indicated that the electrical commissioning could begin, correct?
Counsel, before we ask Mr. Jewell to answer, Counsel, how does this relate to the redirect?
Mr. Ferrari, Mr. Jewell stated in his redirect that all the works in the plant cannot be completed before the final permit was obtained. This line of questioning is important to determine that prior to the obtaining of the final permit, they were in fact completed with the construction and were ready to begin the commissioning process.
Okay, thank you.
I mean, I also struggle a little bit, I have to say, Mr. Darsan, because if you want to, and if you want the witness to confirm anything out of this document, he said already that he was not involved with the electrical commissioning at all. Mr. Watts was, or Miss Watts. And secondly, he's not copied or otherwise privy to this communication. He's probably seen it like I've seen it when I read the case file. So I'm not sure you have the right witness for this sort of information.
Thank you, Madam Arbitrator. In that case, I shall proceed with my other question.
Thank you very much. Now, Ms. Kirichenko, you had something to say. You had your hand up.
No, Madam Presiding Arbitrator, I just wanted to say the objection that you have said yourself.
Okay, very good. So let's carry on, please, then, Mr. Darsan.
Mr. Jewell, I would like to draw your attention to the certificate of completion that was issued. My co-counsel will be putting that up on the screen momentarily. I would like you to read the last paragraph, not the highlighted one, apologies for that, but the paragraph beginning with notwithstanding.
Okay. Notwithstanding the foregoing, this certification is given without prejudice to any right against any third party or AGB which exists on the date of the certificate or which may subsequently come intervene.
Thank you, Mr. Jewell. In your redirect statement, you made reference to surveys regarding local sentiments, correct?
Sorry, what's the sentence?
In your redirect, you made a reference to local surveys that were conducted regarding the general public's opinion of black blades, correct?
Yes, it's correct.
Were these surveys ever provided in their original form to TEPC?
The results of the surveys was provided in my email.
During the construction of the wind farm, Mr. Jewell, did you face any resistance from the community?
Objection, Your Honor. Sorry, Madam President, I believe that the council tried to mislead because the survey were connected to using of black blades, but during the construction, as we see from the case files, AGB did not claim the black. That's why the council tried to manipulate the fact and use, do not connect it points.
Mr. Darsan, anything to say on that?
Absolutely, Madam Presiding Arbitrator. The primary reason that has been stated in that document was that the community would find the presence of the black blades disruptive to the natural environment. At the point the construction began, there was no wind turbines or anything of that sort on the farm. If the residents had an objection to the noise of construction, to the scaffolding that would have been put up, I'm simply trying to determine whether any such things were actually observed during the construction, or whether this survey is simply an abstract theoretical idea of the concerns raised at a different location.
Again, I'm not sure we have the right witness, but Mr. Jewell, maybe, are you able to confirm that either way?
Madam Presiding Arbitrator, I can only say that I have no such information. I only provided the results of its survey. So,
right. So I think, Mr. Darsan, the answer to your question is this is not the right witness.
Madam Arbitrator, in that case, I would like to put the document up, which in fact Mr. Jewell commented on during his redirect. And this was a mail that Mr. Jewell sent to TEPC, correct?
Can you please show me only the paragraphs? Yeah. Yes. Yes. Correct.
Do you have? If I may request my co-counsel to scroll. I think there is a network lag. All right. I think this is perfect. Could you kindly read the paragraph starting from? However, what concerns us the most is the visual impact, the one that is highlighted.
Yeah. However, what concerns us the most is the visual impact that this would have on the landscape and the subsequent rejection by local communities. As you may be aware, one of the challenges that one project faces is community acceptance, which is key for the project's success.
Now, Madam Presiding Arbitrator, the primary reason I was referring to Mr. Jewell's opinion regarding the actual sentiments was because Mr. Jewell had in this message, as you can see, stated that community acceptance was something that they were concerned about. May I proceed along this line of questioning if this satisfies you?
Time remaining.
Sorry?
In the time remaining.
In the time remaining. How long do we have left?
Just one further question, Madam
Okay,
Presiding Arbitrator.
carry on.
Though you have stated that this is one of the challenges, you cannot state, can you state whether any actual resistance was observed during the construction process? Were you made aware of it?
I'm not aware of it, sorry.
Thank you, Mr. Jewell. No further questions.
Thank you very much. Is there anything from either Professor Ferrari or Professor Mistelis at this stage?
No, thank you.
Nothing from me, thank you.
All
Madam
right,
Chair.
thank you very much. I think then we've come to the end. Yes, Francisco, thank you. Come and rescue me. We've come to the, we've come to the end of it.
Assign you to a breakout room so that the tribunal can deliberate.
Yes, I will just say a very short word of thanks to the advocates and the witnesses as well. Thank you very much indeed.
Okay.
Thank you, members of the tribunal and Madam Presiding Arbitrator. Thank you.
Thank you, Honorable Tribunal.
Okay, I believe everyone is in the room. We will start then with the closing ceremony of the first edition of the cross-examination Moot. We hope that you have enjoyed this week as much as we did. We are very happy with the outcome. Unfortunately, due to obvious reasons, we were not able to meet in person, but we could all feel the nice energy in the virtual rooms. And to begin with the closing ceremony, I would like to give the floor to one of the directors of this cross-examination Moot, Professor Franco Ferrari.
Thank you very much. Now, in the 1830s, meaning nearly 200 years ago, one English advocate is quoting as stating that the issue of a cause rarely depends on a speech and is but seldom even affected by it. But there is never a cause contested, the result of which is not mainly dependent upon the skill with which the advocate conducts his or her cross-examination. This is true today as it was 200 years ago, at least to the extent that oratory has not been discouraged by the modern methods of practicing law. In our context, meaning the arbitration context, oratory seems to play a greater role than in judicial proceedings, as confirmed by the fact that, as we know, documents-only procedures in arbitration are very rare, unlike in litigation. Also, I have to add, some colleagues have recently advocated for more documents-only arbitration in these times of coronavirus. In our field, however, in my opinion, cross-examination still plays a role attributed to it 200 years ago. This is because, as stated by Francis Wellman in his seminal work on the art of cross-examination, as yet no substitute has ever been found for cross-examination as a means of separating truth from falsehood, of reducing exaggerated statements to their true dimensions. But the importance of cross-examination is proportionate to the difficulty of mastering its art. In fact, as Wellman pointed out, cross-examination is generally considered to be the most difficult branch of the multifarious duties of the advocate. But this, in my opinion, should not come as a surprise because, and you can see this statement on the website of the Moot, as Wellman stated, it requires great ingenuity, a habit of logical thought, clearness of perception in general, infinite patience and self-control, power to read men's minds intuitively, to judge of their characters by their face, to appreciate their motives, ability to act with force and precision, a masterful knowledge of the subject matter itself, an extreme caution, of course, and above all, the instinct to discover the weak point in the witness under examination. And also there is no doubt that some lawyers have a genius for it. Even these lawyers' genius and talent need nurturing. And in the case of cross-examination, practice. Practice is necessary when one has to deal with a prodigious variety of witnesses and an infinite number of different circumstances. As we can be sure that even Socrates had practice before defending himself about 2,500 years ago against the capital charge of corrupting the use of Athens by way of an amazing cross-examination of Miletus, his accuser. A cross-examination, the account of which, authored by Plato, still has to be considered the most important guide, or to use maybe a more modern word, playbook to cross-examination. And the cross-examination Moot, hosted by Sciences Po, and co-sponsored, of course, by NYU, Queen Mary University of London, and NUS Law, offers a forum for such practice. It is designed to specifically allow participants to hone their cross-examination skills. And from what we could see today, it works. I thank all the colleagues of the board of directors, Diego Fernandez Arroyo, Jasper Nifantemi, Gary Bell, Eleonora Coelho, Sama Haridi, Jan Kaliki, Lucas Mistelis, who was judging today's final, Alexis Moore, and Safi Napat, who chaired today's finals, for allowing me to be part of this. I also thank all the persons who were instrumental to putting the first edition together for their dedication, namely the executive directors who are with us, Francisco Amayo, Ezequiel Vetuli, and the coordinators who helped us not only today, Michaela Apostol and Bas Munich. And it is thanks to their dedication and that of 20 young volunteers that the very first cross-examination Moot was able to host about 40 teams from all corners of the world, 200 students and coaches, and really about 200 arbitrators who judged the cross-examinations taking place over the last few days. It is to all of you that go my thanks, but I think I speak for the members of the board of directors, all of our thanks. Thank you very much.
Thank you, Professor Ferrari. As I said before, we are extremely happy with the outcome of the competition. All the teams have been really, really good. Your preparation has been noted by all the arbitrators. The feedback that we have received from the arbitrators, it has been really great. I remember when the inauguration ceremony, when Professor Fernandez Arroyo said that in Moot competitions, everyone wins. And it is true. I know it might sound a bit cliche, but it's true. It's true. And you will realize, or you may have realized already, that during this competition, you have learned not only cross-examination techniques, you have learned about quantum issues. Yesterday, those who made it to the elimination rounds were cross-examining quantum experts, and the feedback that we received from them, it was also impressive. They felt like they were in a real hearing. So that speaks very well of you. You have learned about procedural issues, confidence, and all the characteristics that Franco mentioned and that cross-examination requires. We are also very glad to see the testimony of all of you, the students, coaches, and arbitrators in social media, confirming the impact that this event has. Of course, we would like to thank the 4 universities that are supporting this competition: St. Paul, New York University, Queen Mary University of London, and the National University of Singapore. To all of the board of directors that Franco already mentioned, and a special thanks to Franco, Sofia, and Lucas for being here in the final. We also like to thank to our sponsors. Compact Lexicon has made a tremendous job with the preparation of the expert reports. They even provided us with real experts to be cross-examined yesterday. The PCA also did an outstanding job with the preparation of the case. Both Compact Lexicon and the PCA were part of the case management, the case committee. So a special thanks also to Carla Chavich and Andres Barrera and their team from Compact Lexicon, and to Julian Bordazar and Martin Doe and their team from the PCA. Also, we would like to thank our sponsors, Maxwell Chambers, CAMSI CVC, and Jus Mundi, because they are the ones, well, some of the ones that will be providing the prizes that we have in this competition, jointly with the internship that it will be provided by Compact Lexicon. Thank you very much to the coordinators. It would have been really impossible to organize this competition without the help of Michaela Apostol, Daniel Gonzalez, Bas Munich, and Paola Patarroyo. Also, a big thanks to the volunteers that worked double shifts in different time zones to accommodate all the teams and all the tribunals during the general rounds. So a special thanks to Sil Saha, Shasandra Davarakonda, Pragya Chaudhary, Manuel Andrade, Courtney Pipa, Rebecca Mateus, Tainá Malta Rodriguez, Mara Villegas, Aleluya Fon, Andra Joana Curutiu, Oscar Figueroa, Min Lee, Nawamaka Okani, and Nicole Alvarez. And thank you to all the arbitrators from all over the world. Some of them are here in the room. Thank you, lastly but not least, to the teams, of course, because you showed that you were up to the challenge. We were impressed by your level, and sometimes it really felt like a real hearing, or even better in some cases. So we do hope that you continue involved in this project, either competing again if you qualify to do so, or as coaches maybe of future teams, or collaborating as arbitrators, or giving us a hand with the organization. But we would like to that you could stay in touch with us. This was a great week, and we are committed to improve and surprise you again next year, hopefully in person, but that is something that we will have to discuss with the directors of the competition. So I guess before going into the announcements of the winner of the competition and the prizes, I would like to play a video that has been recorded by the Dean of Sciences Po. He wanted to be here in person, but unfortunately, due to an unforeseen circumstance, he wasn't able to do so, but he prepared a video for all of you. So I will play that video, and then we will start with the announcements. So let me see if I can do this. Okay. About a minute. Okay, let's see if it works. Do you see it on the screen? Yeah. Okay. Well, I'm not sure whether you will be able to listen to the audio, but let me know if you don't, please. It doesn't work? Okay.
No, not really.
No,
I think I need to, let me go to
we
the
can
options.
see, but not hear.
Okay. There is an option to, let me see. Share sound. Okay, it should work now.
Dear colleagues, dear students, dear friends, it has been a real pleasure to be the academic of this wonderful and innovative event, the Moot in Sciences Po. We are always searching for new pedagogical avenues, and we do believe that Moot play a key role in the education of future practitioners in law. Many thought that it was impossible to innovate, that it was impossible to create anything new in this field. However, after more than 2 years of reflection, intensive reflection, and intensive work, the Moot arose. 40 universities from 20 countries of Asia, Europe, Africa, Latin America were participating in this extraordinary competition. I would like to congratulate all of the teams, its members and coaches for their efforts. As it was said in the inaugural ceremony, all of you have won. I'm sure that irrespective of the results, you have learned more and having great moments together. It has been possible because an incredible team devoted many hours on it. I would like to thank particularly Ezequiel Vituli and Francisco Amalo. Merci. Who together with a wonderful team were the driving forces of the Moot. My gratitude goes also to the thousands of volunteers and the almost 200 arbitrators who were cooperating to make the Moot work. I want also, of course, to thank warmly my dear colleague and friend, Diego Fernandez Arroyo, for his incredible dedication. I would like to also thank our partners in this adventure. I'm talking about the other 3 universities which share the responsibility of the Cross-Moot: Queen Mary University of London, New York University, and National University of Singapore. We are equally committed with an education of quality and have not hesitate in joining forces in this project. As far as Sciences Po Law School is concerned, the teaching and training of mechanism for the settlement of transnational disputes is central. Moreover, we are convinced that the transnational dispute settlement is an art, is a professional specialization, but it is overall a service to the entire global society. This is the message that we try to transmit to our students. Several institutions and companies also support the Moot in different ways. Let me mention the Permanent Court of Arbitration, the Center of Arbitration and Mediation of the Chamber Brazil Canada, Maxwell Chambers, Campus Lexicon, and Jus Mundi. Now, we can't wait to know who the winners are. Actually, I know that. You are wishing that I stop to talk as soon as possible, and you are right. However, what I've told to you at the beginning of this very, very short speech is totally true. All of you have won, and the organizers have won too, because we have shared a magical trip which was able to put many energies in common for a great goal. We are better now than before this first edition of the Cross-Moot. I can't wish you a safe travel back because everyone is at home at this time, but I wish you a well-deserved rest. I wish you un repos bien mérité en français. I sincerely hope that we can meet in 2022 for the second edition. All the best for your next steps.
Okay, then I guess it is the moment to make the announcements. So we will start with an honorable distinction for the teams that made it to the elimination rounds. So as you know already, because we made these announcements after the general rounds, those teams are BPP University Law School, Yara Longhorn University, Hague University of Applied Science, National Law School of India University, Queen Mary University of London, Sciences Po, University of Hamburg, and Yaroslav Mudry National Law University. So all of them will receive a distinction from the competition. And going into the prizes, you know already that those who made it to the semifinal played the Jus Mundi match. And you already know the winners of those matches, who were our finalists, Yaroslav Mudry National Law University and National Law School of India University, who their team members will receive a 1-year subscription to Jus Mundi Legal Research. Then we would like to make also an honorable distinction to the best cross-examiners, although the best cross-examiner of the competition will be the only one that will receive the prize. We would like, nevertheless, to stress out and mention some of the students that made a tremendous job. So we will mention the top 3 cross-examiners of the competition, starting with the third. This is, and if you are here in the room, please feel free to unmute and show your excitement. So the third best cross-examiner of the competition is Maite Aguirre Quiñonero from BPP University Law School. Are you here, Maite? Okay.
Thank you very much.
You are welcome. The second best cross-examiner was Rinreda Sakiyalak from Chulalongkorn University. Are you here, Rinreda? Okay. And then we will move to the best cross-examiner of the competition. And if you could all switch on your cameras. The best cross-examiner of the competition, who will be awarded with an internship with Compact's Lexicon, is Charlotte Lee Parker from the Hague University of Applied Science.
Right.
Are you, Charlotte, here in the room? It seems she's not. And then I guess we have to announce the champion, the winner of the competition. Let me say, I was jointly with Ezequiel and Michaela in the deliberation room, and it was a very tight hearing. But the tribunal took one decision. This is inevitable in every competition. And the winner of the first edition of the cross-examination Moot is Yaroslav Mudry National Law University. Congratulations. So Roman, I see you there. Katerina as well. Would you like to say something?
I would like to start, if my teammates do not mind. it was not on my checklist for this year, to be honest. It was more of a challenge, really. And thank you for the organizers and to all the arbitrators for your amazing feedback. And it was a great, great experience for me. Thank you. I don't think I can provide anything more, just I'm shocked, and thank you all.
May I continue? Okay. I just want to say that it was really, it's the best moot court in what I participated. It was the most interesting moot court. It's a kind of logical play, not something prepared statements that you just read. And I wrote full of my notebook of recommendations. It's insane job.
I can
shortly to that, sorry, Andrei, I just want to say thank you to the opposing counsel. You were one of the best teams with who we played, and there's a lot to learn from you, to all of us. You were amazing, and just thank you for this round.
Yeah, and I just want to also thank you for this very unique experience, because we don't have the disciplines in our country, cross-examination or something like that. And we're very thank you. We appreciate it that you give the opportunity to us. And we also want to thank you, our coach, Evgen Boyarsky, the senior associate of AGA Partners. He made a great contribution for us, and so thank you very much once again.
And maybe I will say for all people that mean this mode is unique opportunity, because each team from during the first rounds, step by step, they had a feedback from the judge, from the honorable tribunal, they improve his feedback, and they run one more time, and this loop provides a way to improve. And I believe it's a really unique opportunity. And one more unique opportunity of this mode, because in the real arbitration, arbiter will never say after the end of the hearing, you may say this, or that, for example, you do not so good in this and you should to improve. That means in a real case, there is no feedback how to improve. But in this case, when we're studying, it's the educational part. And it's really good because we can take a feedback from the most highly qualified specialists in this sphere. That's why I would like to say thank you.
Okay, great. Well, as you know, the winner team, in addition to the US Mondays subscription, will receive a prize in cash, $3,000. Yeah, $3,000. And the runner-up team will receive the same, also a subscription and a cash prize of $2,000. Both sponsored by CAMC CVC and Maxwell Chambers. So thank you again to the sponsors. And before closing this first edition, I would like to give the floor to Professor Fernandez Arroyo.
Thank you, Francisco. Thank you all. Really, I have not many things to add. I think it was really a magical week for all of us. I have only words of congratulation and thank for the teams, in particular the teams and the coaches. That was all due to their work, and we have seen this week really an incredible level of skills. I really can say that, and I am sure that Franco, Sophie, and Lucas share my view. In practice, sometimes the real lawyers doing that are not so good. So really, I hope that we will find you, all of you, very soon in the real arbitration life. I have only words of thank to, in particular, to Francisco and Ezequiel and the wonderful team behind them. Is really because of their work that this has been possible. So we hope that next year we can meet all I don't know if here in Paris or when we will decide later on. And in any event, I hope that you will still be with us in a way or another in the next session of this wonderful Moot competition. So see you next year, and congratulations to all of you. Thank you very much.
Just before we close, I forgot to give the floor to the runner-up team. So in case, feel free to unmute yourself in case you want to comment.
Thank you so much, Mr. Amalo. It was absolutely wonderful experience. And the least I can say is that it was great learning experience for all of us. We can totally see our progress from the first round till here. And the least I can say, it was massive. Many congratulations to the winners and many congratulations to you for organizing this wonderful, wonderful event. Thank you.
Okay, then. So hopefully, I guess that's it for this year. Hopefully we will see you in the next edition, and be ready because in the following months we will announce and we will open the registration for the next edition. So we hope to see you there next year. Bye to everyone. Thank you very much.
Thank you. Goodbye.
Thank you so much and congratulations.